Good morning, everybody. My name is Patrick Fife. I am LIBOR's General Counsel. Welcome to the January 2026 New York or Long Island Legal Update. Hope everybody's doing well. Hope everybody is staying warm. Before I start the content, as I always do with this class, I just want to give everybody a reminder that please check out LIBOR's resources for staying on top of all of the latest trends, changes in the law, things that happen very quickly in our industry. It's tough to track everything that's going on, but we here at LIBOR try to give you as much as you can to help you with that. If you're not getting our emails, please go to the website, lirealtor.com, sign up for them. Really important that you want to get that Thursday LIBOR email. Usually has the most information. We try not to kind of pound you with emails, but that Thursday one is really important. It has a legal tip every week, has all the updates concerning our events. So please go make sure that you're getting that. Also, I'm glad you're here for this class. Feel free to sign up every month. We do offer it for free. But see a couple of you I know on the screen are our brokers, our office managers. We also have a lot of resources for you to help you manage your offices, help you stay on top of a lot of the trends that affect you more in particular. So sign up for our broker webinars that we have every quarter, the risk reduction webinars, and make sure that you're getting the broker monthly newsletter. Again, take a look at the website if you haven't recently. It's continuously being updated with resources. It's lirealtor.com. Has access to all of those legal tips, to our documents on demand, the Dispute Resolution Center, which is where you would go to file an ethics complaint or an arbitration, or also if you need assistance resolving a communication breakdown that you might be having with another realtor. We have an ombudsman and mediation program, which is free. It's very successful. Again, no cost to you, but it's just really a dispute resolution process where another realtor who is trained in kind of communication tactics, bridging the gap, can usually resolve a lot of things that may eventually lead to an ethics, to an arbitration claim. So please, if you've got an issue that you're struggling with, go there. We might be able to assist you. Another area of assistance that you should all be aware of, if you're not already, is we have a legal support center. This is in addition to the NYSAR legal helpline. You have access to both as a member of both NYSAR and LIBOR, but we offer a qualified attorney who can provide you information on real estate matters, 9 to 5, Monday through Friday. It's a great service. I know a number of you have taken advantage of it, and it can be accessed by calling our main number, 631-661-4800, and its extension 335. So I've for the last pretty much year now, since we've had the legal support center, what I've been doing is I get a summary of all the questions that are asked. I incorporate a lot of those questions into the monthly or weekly legal tips, but I also talk about some of them here because my guess is if questions are coming into the legal support center, especially repeat questions, they're probably ones that a few of you here in this class have. So I like to make sure that I cover them here. So this question came up like 3 or 4 times, not specifically as to weight, but the question of emotional support animals. I know a lot of landlords get this question. I know a lot of you get this question. The specific question that came in twice this month was, can a landlord impose a weight limit on an emotional support animal? And the answer is no. Housing providers have to exempt emotional support animals really from any other policy they have regarding pets. So anything regarding weight, the size, the breed, they can't place those restrictions. Remember, emotional support animals, service animals, they are not pets. They are just like the glasses I see a lot of you wearing right now. They're a tool to help somebody with a disability. So a landlord can't impose restrictions on the use of that tool. Unless there's an undue hardship, and I would be extremely careful. Undue hardships are extremely rare. Like one in a couple thousand. It's not something that should be thrown around lightly. So if a landlord says that they have an undue hardship, you need to tell them to speak to an attorney. That is not something you should be weighing in on. There are very few and far between examples I can think of that would allow a landlord to provide that or impose that kind of restriction. So I would say 99.9% of the time, a landlord can't impose any kind of weight limit, any type of restriction on emotional support animals. Um, Totally shifting gears here. I kind of go round, round the globe here with a lot of different topics. But can a listing agent contact a buyer they know is represented by another broker? I think this one's a pretty simple question. The answer is obviously no. It's no different than if a another agent looking to get a listing would contact a client who was represented by someone else. That if you represent, the listing agent and you know that buyer is represented, whether it's exclusively or non-exclusively, you really shouldn't be contacting that particular buyer. They have an agreement with that person. That is their agent. Remember, the Code of Ethics, Article 16, prohibits interference with other relationships. In particular, Standard of Practice 1613 says that when you are dealing or having dealings with a property, you have to carry those out with the client's agent, not the client. So, pretty simple one. A lot of questions this month about the property condition disclosure statement. And this one came up twice. A couple of other questions that I'll go over related to the property condition disclosure statement. So, do I need to have the property or does the seller need to complete the property condition disclosure statement when they're in a state? Answer is no. That is one of the exceptions. There are actually 14 exceptions to who needs to complete the property condition disclosure statement. In addition, vacant land, condos, and co-ops are excluded. That's addition to the 14 separate exceptions. So no vacant lands, no condos, no co-ops. I don't list all 14 here, but some of the more common ones are when you have a seller who's an estate, a seller who's a trust, a seller who's transferring pursuant to a court order. Foreclosure is another common one. In any of those scenarios, seller does not need to complete the property condition disclosure statement. If there's any question, seller should be directed to their attorney. Again, legal question about whether it needs to be completed, have the seller speak to their attorney. Another question I know, another one, new construction. That's another pretty common exception where the seller does not need to complete it. Another question I know that has come up a lot and still does is, well, when does the seller have to provide the property condition disclosure statement? Legally, it's not until the buyer signs the contract, it's before the buyer signs the contract. So it would be at the time when the seller's presenting that contract of sale to the buyer. That doesn't mean they can't provide it sooner. It's really up to the seller and their attorney when they want to provide it. It can be provided at any time, but legally, the buyer does not have to get it until being presented with that proposed contract of sale. If you've got questions, we've got a lot of resources on the property condition disclosure statement. If you just go to lirealtor.com/PCDS, there's a ton of resources there related to the property condition disclosure statement. Frequently asked questions. So please go check that out if you have questions. This is a kind of a general question, but one that comes up and one that I've been asked, and more so by other agents, other brokers who are saying, I see a lot of these advertisements on social media for rentals. People posting it on Sell My Stuff or wherever, neighborhood Facebook groups, that kind of thing. Are there rules for advertising rentals on social media? Yes, there are. It's the same set of rules that apply to all other advertising. I've said this probably 1,000 times. Social media is treated no differently than any other advertising. So there are rules. You have to still identify your broker, your brokerage's name, the address or phone number for the office phone number for your brokerage. It is no different than if you were advertising in print on your company website. So all of those rules do apply, and you can be disciplined for not following the advertising rules. You can't advertise another broker's exclusive listing without their permission. So you can't, find a listing that another broker has and list it on a Facebook page or an Instagram page and try to solicit prospective tenants that way. You cannot do that. If it's somebody else's listing, you need their permission to share it, to advertise it. Also remember, clear cooperation applies. So if you are going to publicly advertise a rental, just like you would a sale, you have to put it on the MLS within 1 business day. And public marketing would include putting it on social media. Same rules apply with sales. They apply to rentals as well. So no different. I know you might see a lot of people out there kind of throwing things on social media without following all the rules. They're doing it wrong. They can get in trouble for it. So please make sure that you are following all the requisite rules when it comes to advertising on social media. Um, Good picture. I put this together a few days ago. I wasn't predicting all the snow. This could be any one of your backyards, I guess, or any place out there with all the snow. But I wasn't trying to depict snow. I was trying to predict, trying to depict some trees on a boundary line. And this is more of a legal question, I know, but I think it's something you should just all generally be aware of and kind of be able to spot the issue. And certainly, if legal questions come up, again, who are we telling the seller or the buyer to speak to? They need to speak to their attorney. But I do think you should be familiar, or at least because this question does come up a lot. Well, what are the rules regarding trees on a boundary line? So in New York, if the tree trunk is actually on the boundary line, which does happen, I've actually litigated cases over this. I've been involved in disputes before I came to LIBOR. I was in private practice. You'd be astonished how many property disputes come down to the location of a tree. But if it's on that property line, it's actually co-owned by both owners. So in that case, neither owner can remove, cut down, damage the boundary line tree without the other owner's consent. So if there are trees that are near the boundary line, again, you have to be very careful. You need to tell whoever your client is, speak to an attorney. There are real significant legal ramifications for wrongfully cutting a tree in New York. You can be held liable for treble damages. And there are cases where people have been found liable for hundreds of thousands of dollars for cutting down very old trees that were not on their property. It can be a very costly and expensive mistake. So you need to make sure that you tell whoever your client is, if there's a question about this, speak to an attorney. Generally, property owners, you can trim overhanging branches or roots up to the property line. So if my neighbor has a tree on their property line, far onto their line, but the branches hang over, I am allowed to trim it, but I can be liable if that action harms the tree's health. So again, there has to be certainly some care used and always tell clients to first consult with their attorney regarding tree removal along a property line. I'm just kind of giving you this as a summary. It's important for you to be generally aware of this is a legal issue, right? You want to be aware of that, but you should not be providing any legal advice to anybody. So hopefully this helps you because I do know it comes up a lot. more than you think. And again, when it does come up, it comes up in a big way. It can cause a lot of liability and potential financial risk to whoever cuts that tree. Another question. This has come up a lot. It's since the NAR settlement. I know there are still some sellers, some listing brokers out there who may be um, proactively offering compensation before buyers even ask for it. So what happens if the seller's offer and they made an offer is more than the buyer agreed to pay me, and I'm a buyer's agent in my buyer representation agreement? Can I take it? Um, Answer's no. If a seller offers more, you can't accept this bonus or additional fee. What you've agreed to with your buyer is the cap. You can't take the excess. You have to use the excess to the benefit of the buyer. So you should be speaking to the buyer, making full disclosure to the buyer. It's the buyer's decision on how that extra can be made. Remember, the whole goal of the NAR settlement and the way that things should be done is that you agree with a buyer up front what your fee is as a buyer's agent, and that's it. You cannot accept anything more from any other source. And if anything more is offered, it's up to the buyer about how they want those funds to be used, if at all. They may just want a price, or they may negotiate for a better price. When you represent the buyer, you're working in the buyer's best interest. It's the buyer's decision on how, if at all, that extra offer can be made. Um, Got questions about that? Again, we've got a lot of resources on the website about the NAR settlement, about buyer representation. So please go take a look there. I'm going to go now through three issues that are kind of my warnings, things that I want you to be aware of for the new year, things that are on the Department of State's radar. And the first issue is still cold calling. If you've taken this class the last few months, you know that I've talked about this, and I'll provide a quick update on things. Cold calling still not allowed in New York. I see a few. I do have a couple of faces in my screen here, and I see a couple people looking a little puzzled. Maybe you haven't taken this class in a few months, but we have a law in New York, general business law, that says you can't make cold calls during a state of emergency, unsolicited telemarketing, sales calls, or text messages. And it applies to everyone. I know some industries may not be following it. And you may also be saying, Patrick, why are you talking about a state of emergency? We're not under one. We actually are under four states of emergency in New York right now. Two due to winter weather, which that confuses me personally, because if you're already under state of emergency for one winter weather scenario, I don't know how you're under one for a second, but we do have two states of emergency due to winter weather. One due to public order at correctional facilities, and another one having to do with federal actions related to vaccine mandates. They're all in effect until at least the late part of February, and I say they may be extended. If you see those numbers, see like EO 47.14 for the one regarding correctional facilities, that means it's been extended 14 times. So that particular state of emergency has been in effect for well over a year. So the governor has kind of continually extended these month after month after month. So until all of these states of emergency expire and we have no others, technically cold calls are not allowed in New York, and you can't make unsolicited phone calls or text messages to members of the public. All other marketing is allowed. And you may say, well, Patrick, who's enforcing this? Right? A bunch of you, and I know myself included, have gotten cold calls from under other industries, and that's true. And they're breaking the law. My concern and my warning to you is that you have a license, right? A lot of these other industries are not licensed, and Department of State gets complaints and they will enforce the law. And they have a division of consumer protection who gets calls, gets complaints, and they will enforce complaints or investigate complaints if they get them. And I am warning you that you can be fined up to $20,000 per call if a complaint is made against you. And I'm also warning you that practically consumers, a lot of them don't like cold calls. There are some that wind up being successful, but generally they don't. And Department of State looks to impose strict liability. It's if they get a record and they can determine that a call was made and they have a record of it, they can fine you and the broker and the owner, regardless of whether they knew their salesperson was making the calls. Um, One reported instance, Department of State is seeking to hold a licensee and their broker collectively liable for over $13 million in connection with over 250 allegedly improper cold calls. So it can add up quickly. That's $20,000 per call, right? So just please be careful. I can't say enough that this is something that is being looked at, and it can really add up quickly. So until the I'm sorry, until the governor has lifted all these states of emergencies, you should not be making cold calls. I will tell you, NYSAR is lobbying hard, and they have been to get this law changed. Unfortunately, it's a bit like pushing a boulder up a hill. Just as a lot of consumers don't like cold calls, I think a lot of state legislators are reluctant to pass a law that effectively allows for more cold calls, right? But NYSAR has gotten the state assembly to pass legislation that would lift this restriction for licensed professionals, as long as they're not going to impair or mitigate a declared state of emergency. They're pushing to get the Senate to prioritize this bill and hopefully get the governor. So very important. I mean, that's one of the main, real significant reasons, you should be active and really support the efforts of LIBOR and NYSAR. It's to get laws like this changed. And this is a hard one to get changed, again, just because there's a lot of consumer pushback against cold calling, but they've gotten so far as getting the assembly to pass it. I'm sure they might be putting a call to action out soon to urge your local state senator to prioritize this. Hopefully, this law does get changed this year, but until it does, be careful. Don't make cold calls when we're under a state of emergency. I also want to let you know that once you're allowed to make cold calls, right? You need to be really careful about the way you're doing it. We have another law that was passed last year in New York that requires you, again, when cold calls are allowed, they're not allowed yet, but when they are allowed, you have certain rules that you will need to follow. It's called the Seinfeld Law. For Seinfeld fans out there, you may remember the episode where Jerry gets a call to his home number and he asks the caller for their home number and says, I want to call you back. And the caller says, well, I'm not going to give you my home number. And Jerry points out the hypocrisy and all of that, saying, well, you're calling me. Why can't I call you at your home? But the purpose of the law is they want you to state your name. You have to state your name. You have to say where you're from. You have to disclose the purpose of the call, reveal if the call is being recorded, and offer the recipient the option to be added to your company's internal do not call list. And if you don't follow this, guess what? You could be fined. $20,000 per call. So once calls are allowed, it's very important that you follow that script. Also important that you're not violating the do not call registry. Department of State can also enforce the federal do not call registry and list. And if somebody's on that list, you cannot make a call to them, and you can also be fined for that. So, my bottom line is brokers, you definitely want to have cold call policies in place. And if you're an agent, you should talk to your broker. Recommend that they put policies in place, find out what they are, but really make sure that you are up to date on whether we're under a state of emergency. And again, we are right now, and we will be until we tell you otherwise. And once cold calling is allowed, make sure that you're following the proper steps. Uh, Consumers will make complaints. They do, they have. And it can really spell disaster for you financially, and also it can impact your license. Unfortunately, a lot of these other industries who are making cold calls, they don't have licenses, but since you do, it can be a big impact towards you. Second Department of State issue I want to let you in on is Department of State issued a warning the end of November about artificial intelligence, and it's kind of a twofold warning here, two parts to it. So I know you all know what AI can do, right? It can really help. I'm sure a lot of you are using it in many different ways, and that's great. You should continue to use it. Awesome. Get trained on it, get ahead of the curve. I think it's AI, whatever tools you're using, can really be a phenomenal addition to your professional toolkit, and it's definitely something you should use. Uh, but it does carry risks, right? It's not always accurate. I can tell you that I play around with it in things that I create, and it's certainly not 100% accurate. It also can create fair housing risks. So if it's being used to generate listing descriptions, the what comes out may not comply with fair housing laws. It may mention about homes being great for families or comment on certain demographics related to neighborhoods when it should not. Some AI screening tools that landlords are using are creating fair housing issues. AI assistants that are chatting with prospective consumers on websites could inadvertently violate fair housing by asking about protected characteristics. So it's something that can create a lot of risk if it's not used carefully. And remember, again, we're in a licensed industry. You have certain obligations in the way that you conduct your business. And if AI violates those requirements or those obligations, guess who gets in trouble? Not AI, you, the license holder, right? So Department of State doesn't have any policy yet on how AI can be used, but they do, and their warning said, look, you need to remember that dishonest and misleading advertisements are prohibited. Those can subject you to discipline. Advertisements have to be honest and accurate. So if you're using AI to enhance photos, to provide listing descriptions, you better double check that what AI's output has given you is honest and accurate and doesn't mislead the consumer. Um, Remember, and Department of State warns you also are prohibited under the general business law from engaging in any deceptive acts or false advertising. And all of this can cause you to be subject to penalties financially, licensure issues. So there are laws that can be used to or applied to the use of AI. So I mentioned the alert that Department of State issued, and it was an alert to home buyers and also to you real estate professionals. And it said, look, there's a big rise in AI, in particular with artificially generated pictures on real estate listings. And they also warn that it is something that they predict will be used more and more to help with marketing properties. But they want you to be aware. And I say when they want you to be aware of something, that means they're looking at it, right? They're getting complaints about it and they're going to take it seriously. So it's not going to be a defense that, oh, well, my advertising wasn't accurate. I relied on AI. I'm sorry, AI output was made a mistake. It's not going to be a defense, especially when Department of State's warning you. So you need to really carefully scrutinize whatever output you're getting from AI. Um, so the warning from Department of State, this is a quote right from the Secretary of State. It says, while AI can help home buyers imagine what potential home can look like, these automated technology tools may produce misleading or exaggerated representation of properties. I urge real estate agents to be mindful when listing and consumers to be vigilant when searching for their dream home. So that's it. Be mindful. Don't just blindly or use AI without giving it a second thought. You need to really carefully scrutinize AI that you are using. Does the use of AI images, and this is something that I think is really important for you to consider, does the use of AI actually help your business? Um, is it something that you should be using? Um, DOS alerts, DOS, I'm sorry about that. DOS alert, their alert says, there's certainly legal risks, but they cited a study, and I thought this was really interesting and something you should consider. A lot of consumers actually distrust AI generated images, and they perceive them as less authentic, less professional, and misleading, which negatively affects consumer trust and purchase intentions, particularly for high investment decisions, which obviously a home is probably the biggest investment that most people will ever make in their life. So, just a warning, that you should really consider how you're using it. The second part of the warning, though, and this is the other piece that I want everybody to really focus in on, is DOS warned that AI is being used to impersonate real estate professionals. There are scammers out there posting fake listings, usually rentals, trying to scam prospective tenants. They are often using not only copying images or listings, legitimate listings, but doing a lot more to impersonate and using AI to impersonate real estate licensees. I wish I could give you guidance on how to absolutely prevent that from happening. I can only give you a couple guardrails that might help you. First thing is, I want all of you just regularly. I know this sounds like a lot, but it's really not. You should just routinely check and see, is anyone else using your identity? Is anybody else posting your listings? Put it in your calendar the first of the month, the last of the month, whatever you want to do. But say, hey, I'm going to just do a Google search and do a social media search, whether it's Facebook, Instagram. Just make sure no one else is out there using my profile or copying my profile. It seems to be more prevalent, especially that the scammers are targeting those of you that don't really have a big online presence because it gives them, hey, they look like the legitimate licensee. It's a lot harder, I think, to dupe somebody into thinking they're dealing with the real licensee when that person has a pretty significant online presence. But I urge you, just check. Do a regular search. Takes 5 minutes out of your month, less than an hour out of the year. Take a look, see what's out there. The second thing I think you should all do is make sure that you have safety features, security features like multi-factor authentication on any tool that you have to access important information or to put out important information. So that includes your MLS account, whatever other programs, online tools that you use for your business. You want to make sure that you've made it very difficult for anybody to get access to that. So your email, make sure that you've got password, you're routinely changing your passwords, that you've got password protection tools, that you've got multi-factor authentication. It is a real risk if one of these scammers gets into your account because now forget it, they look as legitimate as you. They can really act as if they are you. So lock down and make sure you have the ability to lock down all those tools. Um, I think every broker should have an AI usage policy. They should have protocols, and all of you should make sure that you're reviewing all your AI generated content for accuracy. Don't put any personal, financial, confidential information into an AI tool. I've heard attorneys who have done this, and they put in contractual provisions and they leave the parties' names in or they leave sensitive information in, right? Remember, it's generative, so whatever is being put in can then becomes kind of the property and used to train that AI tool for others. So if somebody put in confidential information related to a contract, and I happen to a week later ask, let's say it's ChatGPT for a sample contractual provision related to that same exact topic that that attorney put in, guess what could come out? That actual provision that that attorney or the modified provision with all the confidential information. So don't be putting it's not confidential. Once it's out there for everybody. I would strongly urge you to have certain AI approved tools, especially if you're a broker. You don't want people going out there and just using anything off the internet or off the shelf. Um, don't use AI for contracts or legal advice. Attorneys should not be doing it. So certainly, real estate licensees, you never should be using. Still turn to an attorney. The defense that while AI provided the advice is not one that can be used. You want to have standard disclosures for any AI drafted material. So that would include photos. You want to identify if something's been altered, if it's been, modified by AI. Include a disclaimer, and you also want to include a side-by-side image if you can, saying, current photo or original photo, AI enhanced photo, whatever it is. Make sure that you have a standard disclaimer on any photo that you have enhanced or modified using AI. Last topic that I do want to cover related to kind of Department of State and issues that are on their radar. And this isn't just Department of State. I think there's really an increased effort at the government level to I'll say police rentals and enforcement of the law when it comes to rentals. I know it's a big initiative in New York City under the new mayor. But this warning I think goes further than New York City. I just think that you really need, if you're going to work in rentals, you really need to understand what the rules are, and make sure you're following them. Not only is it an enforcement issue, it's also testing. Much easier for undercover testing and rentals to be done when it comes to things like fair housing and other compliance with other rental laws. So, because of that, you're always at risk for being tested. You're always at risk for, with the government really kind of making sure that you're doing things the right way. And also, I think the other aspect is rentals are very regulated. So you really need, if you're going to practice in that area, you really need to understand what the obligations are, what the laws provide, and don't dabble because that's how you get in trouble. So first, if you are in New York City, and that's the five boroughs, right? That's not Nassau County, that's not Suffolk County, but it is Queens, and we have a lot of members in Queens, and we have a lot of members in Nassau and Suffolk who have listings in Queens. If you're dealing with residential rentals in New York City, any of the five boroughs, make sure that you're in compliance with the FAIR Act, which is the Fairness in Apartment Rentals Expenses Act. And that prohibits landlords from passing the fee of the broker they hire on to prospective tenants. So the landlord cannot require the tenant to pay their broker fee on any residential listing in New York City. Question that comes in the legal support center at least once, sometimes twice a month is, well, what about Nassau County? Again, this is just New York City. It doesn't apply on Long Island. But it's any fee, right? It's not just the broker fee. Landlord's agent cannot impose any fee or collect any fee from the tenant related to the rental of residential real property. So the landlord and the listing broker can't disguise it as something else or call it something else when it really is a commission. It's any fee. Landlord's agent cannot impose a fee on the prospective tenant. Doesn't prohibit if there's a tenant's agent working with the tenant and they have a tenant representation agreement, that's different. We're talking about the landlord's agent can't collect any fees, broker fee or otherwise, from that prospective tenant. So make sure if you're dealing with anything in New York City, you're aware of that. I also want to make sure that all of you are aware, this is statewide now. Your listings should not and cannot seek illegal or excessive deposits or application fees. Since 2019, so it's been almost 6 years now, we have a law in New York that says you can only charge up to 1 month's rent for a security deposit or advance payment. So a landlord can't charge more than 1 month's security. And a landlord can only charge that first month's rent up front. They can't charge first month's and last month's. If they are and you're advertising it, you're breaking the law, and you can be held liable. Landlords can also not collect application fees. That means you too, you cannot collect an application fee. See a lot of this out there. This is grounds for discipline by Department of State. This is grounds for being in trouble with the Attorney General. Landlords in New York State cannot collect application fees. They can also not charge more than $20 for a background or credit check. That's it. That's the only additional fee that can be charged. And the fee has to be waived if the applicant provides their own credit or background check within the last 30 days. So make sure you're not advertising or seeking or collecting any more than what is identified on this page. Very important. And this, again, is statewide. This is not just New York City. And I do think that, in particular at the city level, but also the state level, we're going to see this year a more aggressive enforcement when it comes to these laws. I already mentioned this before. Remember, clear cooperation, this is an MLS rule, does apply to rentals. So once you publicly market a rental, you have to submit it to the MLS for cooperation within 1 business day. I put the rule here, just so everybody's aware. And this is in the MLS rules. It doesn't, we get calls. I know to the Legal Support Center, not sure. MLS rules are really easy for you to find. They're on the One Key website, but residential rentals are included in clear cooperation, just like sales. So residential property has to be put on the MLS within 1 business day of marketing that property to the public. And marketing does include social media, and really anything else. Another important point, and this is again statewide, this is not just New York City. Make sure you're providing a reasonable accommodation and modification notice to all prospective tenants. This is a state required form. It's not the housing and anti-discrimination disclosure form. It's an additional form that has to be provided to all prospective tenants, and it lets them know that they have the right to ask for a reasonable modification or accommodation if they're disabled. A link to this form also has to be posted on all the brokers' websites and prominently displayed on the homepage. And you're going to give this at first substantive contact. So if you're dealing, you should have a packet, you should have a process. You're dealing with the tenants, right? You're going to give all prospective tenants, 3 things at a minimum. You're going to give them this form. You're going to give them the fair housing, the an anti-discrimination disclosure form, and you're going to give them the agency disclosure form. And you're going to give them each one. You're going to explain what it is, and you're going to have them sign it, right? So this one doesn't have to be signed, but this is a notice that you must provide to all prospective tenants at first substantive contact. Um, Last point, just be careful if the landlord wants to charge an extra deposit for pets. Um, Remember, 3 or 4 slides ago, what did I say? How many months can you ask for security? 1 month. That's it. That's the total. So if there's a pet deposit request that exceeds that 1 month or is in addition to the 1 month security, the landlord can't ask for it. Landlord's sum of all deposits, including pet deposits, can't exceed 1 month's rent. Landlords can charge pet rents. They can charge a greater rent to a tenant who has a pet. That is permitted, completely legal. However, just remember that cannot be applied to service and emotional support animals. So that goes back to, I think, the first question that I covered today under the Legal Support Center. Um, Pet and extra security deposits can't be charged for service and emotional support animals because they're not pets, period. Next thing I just want to cover, and this relates to rentals as well, and it's kind of an extension of the topic we just covered, and it's still the number one area of undercover testing when it comes to the subject of fair housing in rentals, and that is lawful source of income discrimination. Um, you've anybody who's taken this class in the last 3 or 4 years has heard this already, but I have to repeat it, and I will continue to repeat it until we get to the point where you'll see in 2 slides from now where we don't have a headline every 2 or 3 months where somebody has violated the law. Because it's just this is just something that the state has gotten to the point where they have told, I've heard this directly from Department of State, that they're not tolerating this anymore. Um, Lawful source of income has been a protected class now for over 6 years in New York State. So they don't have any tolerance. If somebody breaks the law in this regard and discriminates on the basis of lawful source of income, they will seek a suspension or revocation of your license, period. That is it. So that's why I just want to reiterate how important this is. And it's just something at this point that no one should make a mistake on. There's no tolerance from Department of State. So I want to make sure that every one of our members understands what lawful source of income is and how what you need to do when it comes to dealing with somebody who does have a voucher. So housing providers can ask you all about your income. They can ask you where it comes from, what it is, how much it is. That is not discrimination. But they have to accept all lawful sources the same, meaning treat everybody equally. So no matter where my income comes from, a landlord has to treat it equally. They can't just say, well, I like somebody who gets one form of income, let's say from a job, better than someone who gets their income from one of these other sources. And the big one that we constantly see issues on is individuals who get their income from vouchers, whether it's Section 8, housing choice vouchers, some other um, program that provides support for tenants. And I mentioned about a minute ago all of the recent news reports of source of income violations. Just had one a month ago. Uh, Division of Human Rights announced a $40,000 settlement for agents who unlawfully refused to engage with potential tenants who indicated that they'd pay their rent with housing vouchers rather than income. So you can see these numbers are big. Um, Again, just last year, a Long Island agent allegedly told testers they couldn't use Section 8 vouchers or Veterans Affairs supportive housing vouchers to pay rent. This is not something that I'm just kind of pulling out of thin air. These are just a few reports, and you can see the fines and penalties and settlements are significant. And I can also tell you in all these instances, Department of State will then also look at the individual licensee's license and the broker as well. So it's so important that you understand this, and it's really, really, really easy to comply. So doing any of these things that I have up on the screen, that is discrimination. Saying you don't work with voucher holders, or you have to see if the landlord will or the landlord won't, or the apartment doesn't take vouchers. It would be no different than you saying this apartment doesn't take people who practice the following religion. This apartment doesn't take people who have this color skin. It's the same thing. It's just outright discrimination. It won't be tolerated. It shouldn't be tolerated. I just mentioned here's just another recent instance. This was a case from that was reported in December, just with testers. A third party Fair Housing Justice Center conducted testers with testing with proposed renters. Some who said they had jobs, some who said they had vouchers. And agents just simply didn't respond to the people who said they had vouchers. Or in other instances, they said, well, vouchers are not accepted. It's illegal, it's discrimination. So what do you do? Well, really easy. I mentioned before that you just have steps where you treat every single person, every prospective tenant who calls, treat them the same way. Doesn't matter if somebody has a voucher, you're going to ask the same questions to every single tenant who calls you, who walks into your office, who emails you, who texts you. You're going to, and these are just my suggestions, but you can have a script. And what area are you looking for? How many bedrooms and what's your price range? Right? That's it. You don't turn away anybody who says, well, I have a voucher. You just say, well, look, okay, based on that voucher, here are all the vacancies that meet your needs. Period. You show them the same apartments you would any other prospective tenant, and just get the information from their program. Ask for a copy of the voucher, their caseworker, and find out the details of their program. If an owner won't work with somebody who has housing subsidies, you know what you do? You don't work with them anymore. Real simple. You cannot disregard the law as a real estate licensee. If a client wants you to, they should no longer be your client. You tell them that you can't follow their directive, you stop working with them, and you document your refusal to work with that person, period. Again, source of income discrimination is treated like any other form of discrimination. This question, I think every single time we do a program on source of income, it comes up is, well, credit scores, and can landlords ask for certain credit scores? Can they ask for certain income? Yes, they can. It's not illegal to advertise, right? But if a tenant who has a voucher that covers 100% of the rent, landlord cannot apply that credit score minimum or that income minimum to that prospective tenant. If the tenant has that voucher that covers the rent, those scores are irrelevant. They can pay the rent. The government has already said they can pay the rent. Applying any kind of credit check or income requirements would preclude that person from ever getting that apartment. It would be discrimination. Um, if the tenant has a voucher that covers a part of the rent, uh, those other factors can be applied on a case by case basis, but be careful. It can still violate the law because if it's being used in such a way to prohibit someone with a voucher from ever getting that apartment, um, again, it's discrimination at that point. And it especially may not be a valid indicator if somebody can pay the rent. Most of these programs have already vetted the maximum, even if somebody only has a voucher that covers 70%, they vetted the person and their ability to pay up to a certain amount. The programs have done that. They've looked at other factors that that person presented. So, talk to the particular program, find out what that person has not only been approved for the voucher, but what rent they are approved for. And in that instance, credit score and minimum income is probably not a valid indicator as to whether somebody can pay the rent. Last topic I want to cover we've got about 2 minutes. I just want you to really consider avoiding the practice of buyer love letters. This is something I used to go over more, but I've heard that this is something that's sort of made a comeback. I know we are still, especially here on Long Island, at a very low inventory and still a very strong seller's market. Buyers are really struggling in some instances to stand out, and they may think, hey, if I write a letter to the seller, I may stand out more. Maybe they'll pick me. I want to explain to them why I'm the best person for them to pick. It's not illegal, um, but it's highly discouraged because when they say, pick me, right? They may start indicating things about themselves to the seller that may reveal a protected class, and that gets into problems, right? So even just saying, hey, we're the Smith family, or revealing something about their religion, or anything about themselves as opposed to the property, it creates an issue for the seller. Because if a seller decides to sell or not to sell to a buyer based on something that was revealed in that letter that reveals the buyer's protected characteristics, seller could have a real problem, right? Because then there's always the potential to allege that, well, you either picked me or picked that buyer over me because they revealed something about themselves or because they were a particular race, religion, color, nationality, or or they didn't pick me because they knew that I was a particular race, religion, nationality, color. It becomes a real problem, and it can become a problem for you if you're the one that suggests the letter or is involved in the delivery of the letter. So I just and this is all on the website. We've done articles on this. I would discourage the use of these letters. Don't be involved. If you're representing the seller, I would say to the seller, it's not something you should ask for. It's not something you should consider. Same thing with the buyer. I would say it's not something that I can be involved with. I'm not going to deliver it. And just make sure you document your advice. Don't be involved in it. Um, if you've got a buyer who insists, make them deliver it. And also, sellers can instruct not to accept any offers with personal letters if they really want to minimize their risk. So, with that, we are at 11 o'clock. So, I am finished. Thank you for your attention.